Hello and welcome to Legal Talk, a program brought to you by the law firm of O'Donnell, Weiss & Mattei, PC. We have full-time offices in Pottstown and Phoenixville, and you can visit us at owmlaw.com. Today we have a program that is actually of vital interest to everyone, including us, you. There are changes that have been made in the law involving our life planning. And this is an estate planning feature. We have attorneys in our office who concentrate their practices, and part of the practice group that does estate planning are our guests, John Koury. John, welcome, and Rebecca Hobbs. And I'm David Kaplan. I'm also part of this estate planning practice group. So today we're going to be revisiting an issue that we talked about before, and that is powers of attorney. It may not sound exciting, but frankly it is probably the most important document that you can have for your lifetime, for living out your life. And Jack, let me begin with you and just ask, what is a power of attorney?
A power of attorney is a written document in which you as the principal give another person, who we'll call the agent, the authority to act on your behalf for purposes of spelling out duties and authorization, literally, during your lifetime. Most powers of attorney are called durable powers today. Durable simply is a word that means the power of attorney, once executed and unless changed at a later date, will continue until your death, at which time it will expire.
Now, I mentioned at the outset, this is probably as important a document as you can have for your lifetime. And why is that? What's so important about a power of attorney?
Well, specifically, the power of attorney gives the principal, who in this case would be our client, control during their lifetime over very important decisions relating to their financial affairs and life in general. I say life in general because there was a time when we combined a lot of information in a power of attorney. You'll hear later where they're separate documents, but it's really to avoid the need for a guardianship where you have no control over the court appointing a guardian. And those situations occur where the individual has not executed a power of attorney, written power of attorney during his or her lifetime, and is in a position of not having one.
So what you're saying is that if in fact you don't have a power of attorney, and we're talking about and I'll ask Becky in a moment about some of this, but there are different types of powers of attorney. But if you're not able to run your own affairs, take care of your own affairs, that you would actually have to go to court and get a guardian appointed. And that's expensive and time-consuming.
Very much so, and not only that, it's almost involuntary as far as the principal is concerned. If you're not able to act for yourself because you're incapacitated, the orphan's court will do it for you, in which event you will not have any control over who is appointed. It will be expensive. A physician's testimony is required, and it becomes an elaborate procedure which could have been avoided with a written durable power of attorney executed during one's lifetime.
Well, and today we're going to be discussing financial power of attorney primarily, and in fact some of the controls that you can have per the new act, the new law. And Becky, when we do powers of attorney, people come to our office. A lot of times they come in and they say, I'd like a will. But we don't let them out of the office with just a will, because that's, frankly, I almost feel a legal malpractice not to allow someone to walk away and not do lifetime planning for themselves.
David, before Becky responds to that, we've had many situations very specifically related to what you just mentioned, where the family comes back to us later and says, you had mother and dad in the office for a will, now we need powers of attorney, and we don't have them. And it's no defense on our part to say they wouldn't allow us to do it, they wouldn't authorize it, we recommended it, But in today's world, we not only recommend it, we do it.
We do it. We require it.
That's right.
Because that's good legal practice. Becky, I was starting. There are different types of powers of attorney, and typically when a person comes into the office, we really do 2 documents in addition to any will or trust we do.
Right.
Explain that, please.
Yeah, a lot of people are most familiar with the financial power of attorney, and that is the document that we were just discussing. The healthcare power of attorney is very much like the financial power of attorney, however it relates specifically to your health. And it's a 2-part document. So generally it's going to have a living will portion, which many people are familiar with a living will and what that document is. And the healthcare power of attorney has a very important component to it, which is the HIPAA authorization. And that is when you go to a doctor's office, when you go anywhere for any kind of health treatment, in order for that physician to release information to your family members, they need to have your authorization to speak to the family member about that. So the healthcare power of attorney, you can appoint an agent, very similar to the financial, and your agent would be able to communicate with your doctors, be able to get information on prescriptions that you're on, or just talk to them about your health situation. And then it also allows that agent to be able to step in and make decisions regarding your health when you're not able to make those decisions. So when you don't have the capacity, whether you God forbid, get into a car accident and you're not able to authorize a certain surgical procedure, it appoints that agent to be able to step in and make those decisions for you.
And the healthcare power of attorney, of course, has the living will provisions
Right.
now, and that law actually was revised effective January of 2007. So, and that has not changed, has it?
Correct. That has not changed. And the living will portion, that kicks in when you have an end-stage medical condition and you're not able to communicate regarding what your wishes are. So that document, you can choose and lay out what your wishes are regarding end-of-life treatment.
Okay. And Jack, we didn't, I think you alluded to this earlier, we didn't used to do it this way. We had one document for many, many years that we used. We didn't actually have a separate healthcare power or living will power, did we?
That's correct. We only had one document. It combined your financial affairs, control over your financial affairs, had some references to healthcare powers, and it was much simpler and concise than what the law now requires. And I think the law requires that it be a little bit more elaborate, and I think our viewers will appreciate that as we go through this seminar.
Yeah. Now, Becky, give us a little background on, there is a new law, I think we just said that it does not impact on the healthcare power and the
Right.
living will.
Right.
It's really just the financial power of attorney that we're talking about. Give us a little background on when that came into effect.
Sure. So July 2nd of 2014 is when Act 95 was signed into law. And Act 95 specifically brought changes to Title 20 of the Pennsylvania Consolidated Statutes, which governs the power of attorney, specifically the financial power of attorney. And some of the provisions of Act 95 were effective immediately upon it being signed into law. However, primarily most of the provisions were effective as of January 1st of this year, 2015. And a lot of those provisions we're going to walk you through today as far as the specific important provisions there that we need to know about.
Yeah. And actually, why don't you begin explaining, Becky, about there are issues involving notice and acknowledgement things. Could you explain what that is?
Sure. So prior to the new act, there was what we called a notice page. And the notice page was the first page that the principal, that's the person that's actually signing the power of attorney document, would sign. And there are also acknowledgement pages that each of the agents, the person that you were appointing to make your financial decisions, would sign as well. And the new law, Act 95, changed the wording in the notice as well as the acknowledgement. And they made the wording a little bit more stronger in order to warn people of the importance of these documents and to help to protect some abuse, some elder abuse when it came to these documents. And some of the wording in the notice page specifically lets the principal know that by signing this document, your agent could potentially go and gift all your assets away. That's one of the new warnings on that notice page. And then as far as the acknowledgement page, one of the main changes was it lets the agent know that they have to act in the principal's best interest with good faith and within the reasonable expectation of the principal. So the new law just changed the wording in those documents. They look very similar to how they looked previously. It's just some of that wording has changed.
Okay. And Jack, there are some changes also in what they require now with what we call execution of the documents, which is a fancy way of saying signing, to sign the documents. How's that changed in the law?
Under the old law, the only requirement was that of a notary, excuse me, and that was easy, and there were no witnesses required. Under the new law, 2 witnesses are required, 2 individuals are required to serve as witnesses, and they must sign and witness in addition to the attachment of a notarial seal by a notary public. And I would suggest to you, Dave, that we've always had issues with execution in terms of the need to meet with the client face-to-face. Many clients will consider, before they come to us, perhaps doing internet or documents they found on the internet. And ethically, as lawyers, we're really not permitted to prepare documents, release them, and put the clients out there on their own. So what the code is doing now is tightening up a bit, and it's requiring very specific execution requirements. And the purpose of that is so that the clients understand fully the impact of the provisions of the powers.
And I guess the good news for us at OWM Law is that we've been doing this for years in terms of the way we go about having these documents signed.
We have, and in that process, we probably spend more time with clients than clients might anticipate when they come to see us in the first instance. But the time we spend with clients is very important because these life planning documents, that's what powers of attorney are, as contrasted to wills, which are death documents. They become operative at the time of death. Your powers of attorney become operative when you sign them, and they become effective when they're delivered to the individual agent named in the power. So you have a situation where before signing the document, it's very important under the new law that the clients understand the difference between the mandatory provisions that are required now under the law and certain other provisions that you can waive if you care to. Waive means determine or make a decision that you do not want those provisions included. And that distinction is what has to be explained specifically to clients so that they fully and completely understand the document, content of the document, before they sign it.
And would you just talk a little bit about the duties of the agent? And actually there's some changes in that as well, are there not?
There are, and it's very clear that under the new law, the duty, as we've always believed it to be, but now it's memorialized, is that the principal has to act, the agent has to act in the best interest of the principal, has a duty of good faith. The agent is also limited to act within the scope of the duties, of the powers that are specifically set forth in the document. And there lies the distinction between waived powers if the client suggests that they're not interested in giving certain authority to the agent. They do not have to give that authority. They can be waived. And in addition, you're going to hear shortly where the powers of the agent have been greatly expanded in the event that the principal wants to expand those powers.
Well, why don't we move on to Becky and let her discuss that a little bit. Earlier we said, Becky, that there's more control now under the new act, that the agent actually has a lot more authority. And I think we should probably take a break right now.
Okay.
That's a teaser. That's the question we're going to start with. We'll listen to some very good messages from our sponsors and be right back to you.
How would you build the perfect bank? Would you put it close to your home or your work? Would you make it a high-tech wonderland with web banking and 24-hour access? Or a hometown bank with tellers who know your name? If you could build your perfect bank, it might look a lot like National Penn Bank. Convenient branch and ATM locations, innovative technologies for 24-hour access, attentive personal service, and free checking with no minimum balance or monthly account fees. It's all right here at National Penn Bank.
There are many reasons people join AAA and renew their membership year after year. In addition to the peace of mind of emergency roadside service, AAA membership includes expert travel planning, exclusive discounts, and more. AAA members also get exclusive Show Your Card and Save discounts at participating retail merchants and can save money on theme park tickets, luggage, and travel accessories at the East Penn Travel Store. Join today and start taking advantage of all AAA East Penn has to offer. And visit us on the web at www.aaa.com.
Welcome back to Legal Talk, brought to you by O'Donnell Weiss Mattei PC. Please visit us at our website, owmlaw.com. And today I have Rebecca Hobbs and John Koury with me, David Kaplan, discussing issues that impact on all of our lives. There will come a time for most of us when we need someone to give us a hand. There will come a time for most of us when we will probably not be able to take care of all of our own matters, and we'll need someone to step in. And instead of having the judge, good judges they may be, but instead of having a judge appoint someone, having someone that you want to take care of things and helping design what it is you think that they should and should not be doing. And that's where we really left off. Becky, I was raising that question with you at the break. The new law that went into effect in January, basically, that law actually gives authority to the person signing the power of attorney, the principal, to design, they can design somewhat what it is that their agent can do.
Right.
And could you explain some of those options and how they may impact?
Sure. So the new law, specifically, I think this is one of the biggest areas they've changed, and that is that if you want your agent to have certain powers, which we'll go over each of these powers, you have to expressly grant your agent that power in the document. And some of these powers, when you first hear about them, you might think, well, why would I want my power of attorney, my agent, to have this power? So we're going to give a few examples of when it may be beneficial to have these powers in your document. And with these changes, it's become very necessary for the principal, the person that's signing this document, to work with their attorney to make sure that the document is customized to their needs. And these powers are one of the main reasons as to why you need to have that customization in your power of attorney document. So a lot of attorneys or practitioners refer to these express powers as hot powers. And one of the hot powers is the power to gift. So the principal can give their agent the power to gift their assets away. And it can be unlimited gifting. So there can be no limitation to the amount that they would want their power of attorney, their agent, to gift.
So there would be a choice between what I believe are limited gifts and unlimited gifts. And correct me if I'm wrong on this, but limited gifts are those that normally are granted under actually the Federal Gift Act with being able to give up to $14,000 a year away to any one person.
Right. And the limited gifting actually got changed a little bit in the new law as well, because now it's limited to not only amount, but a certain class of people as to who you can gift those assets to.
Such as?
Such as family members, so your children, your spouse. So it's more limited, where the unlimited gifting, you can add those limitations to it. But one of the main ways that we use this power, the unlimited gifting, and where it may become helpful for some clients. Again, not every client is going to want to have that broad power placed in their power of attorney document. But where we use this power most commonly is where you have someone that wants to apply for Medicaid benefits or veterans benefits, and that power to make gifts may be very helpful in order to help make them eligible for those benefits that they're applying for.
So that would be typically, and even though I know it can apply to a younger person, but more typically an older client would be someone that we would look at maybe giving unlimited powers. They would want to give unlimited powers.
David, I think that the reason or the issue which we want to emphasize to our viewers is that in today's world and under the statute that we're presently bound, clients have to understand the extent of these powers and how they work. And that means that we're going to be spending more times with clients. We're going to have to give them examples specifically as to why in each individual situation more greater power rather than lesser power might be necessary, depending on the overall plan for that individual's estate.
Well, that's a good point, because actually it's somewhat frightening to think that you're giving such broad powers to someone, but as Becky was explaining, and you're saying, Jack, it's these powers, there are really good reasons for giving these powers.
There are, but I think what it goes back to, or what it comes to, is the basic attorney-client relationship. We give advice, we make recommendations, we do not make decisions. And the decisions for the client, and this is many times it's taken the client forever to get to us because they procrastinate. That's normal. But they need to understand these are decisions that the client makes, the lawyers do not. We just give advice.
Okay. Becky, could you give us another example of an authority that may or may not be limited?
So another one is the ability to change a beneficiary designation. So if you would want your agent to have that power. And one of my favorite examples when it comes to this is I did have a client that had come to meet with me, and they were brought by their children, they no longer had the capacity to be able to sign legal documents, and they had a power of attorney already in place. But their agent didn't have this power, this specific power to change beneficiary designations, and there was an old life insurance policy that had an ex-spouse on it. And so we wanted to be able to change the beneficiary. There was no contingent beneficiary designation listed. And so it would have been helpful in that situation to have that specific power where the agent could sign a new beneficiary designation consistent with that individual's estate plan. And that person's estate plan, they wanted everything left to their children equally. And so we could have, had that power been there, signed a change of beneficiary form to add a new beneficiary, which would have been helpful.
And in a typical well-drafted power of attorney, there are actually different types of beneficiaries as well.
Right.
You mentioned for a life insurance policy, beneficiary there. But you're also have it even with wills and things.
Right. So your agent cannot change your will. So that's something that they do not have the power to change your testamentary estate plan. So these powers specifically relate to the ability to change beneficiary designation, which are your non-probate assets. So your retirement accounts, your annuities, things to that effect. And again, it may not be a power that everyone would want to have in their document, and it goes back to what we've been talking about as far as the relationship that the attorney needs to have with the client, and the client with the attorney to go through these powers and determine what is necessary for their specific estate plan.
Okay. Now, Becky, you've really been involved in this whole issue of the changes. I know you are very much involved in elder law issues in Pennsylvania. There was a case that really moved this all ahead. Vine versus Commonwealth of Pennsylvania. And could you give us a little background? What is that case about?
Sure. So this was a 2010 case, and it was a Supreme Court case in Pennsylvania. And the case specifically related to a power of attorney document. and it was the Commonwealth of Pennsylvania, the State Employees Retirement Board, and it specifically related to a third party, so the retirement board, that relied on a power of attorney that on its face looked valid. They were presented with a document. They believed that it was valid. There was nothing in the factual situation that would make them believe that this power of attorney was not good. And so they relied on the power of attorney. And later it was determined that at the time the principal signed the document, they didn't have capacity. And so the power of attorney was not good. It wasn't valid. And this case held the third party liable for that, even though there was no way of them knowing. And the result of this case was it made banks, financial institutions, third parties very hesitant to rely on power of attorney documents.
Which is really interesting because I remember last time the powers of attorney were revised, the law was revised, my understanding was that, people can rely on these. There shouldn't really be a big controversy. And I always told clients, don't worry. Now, Jack, you've sat on bank boards. You have, so you've been a director at banks. You've worked with banks extensively in your legal career. Has this been an issue that's popped up with the banks that you've worked with?
It's not only an issue that's popped up with the banks that I've worked with, but with all banks. Over the years, when lawyer drafted powers of attorney were presented to banks, many clients got surprised that the bank didn't automatically accept them, but not as frequently as has occurred in the last 8 to 10 years. And the reason for that, the banks are considered third parties, as Rebecca has used that term, and their willingness or desire to rely upon a power of attorney has not yet changed. They want to rely on that because that's really their link with the customer and their link to confirm that they're doing the right thing and operating within the desires of the customer. More recently, banks have been criticized for being reluctant to accept powers of attorney as drafted. And you have to appreciate that banks receive documents that clients have prepared themselves. In today's world, they download them from the internet. They believe that what they're doing is proper and represents the correct language. And banks also look at professionally drawn powers of attorney by members of the Bar of Pennsylvania. And in comparing the two, the banks have become a bit more cautious, not necessarily in favor of either.
So Becky, what did the law do to help make banks feel better and most reasonably feel better?
So the new law provided a layer of protection for third parties that basically said that if they rely on this power of attorney in good faith, then, and that's the key, is they have to have good faith that the power of attorney is not invalid and that it has not been revoked. And then it also provides steps that third party, the bank, can take to protect themselves. So certain steps they can take to make sure that document is valid. And one of the things that they can do is they can ask for an opinion letter from an attorney, basically saying this document, is in full effect and that it hasn't been revoked to their knowledge.
So Becky, what you're saying and telling the viewers, I believe, is if the customer comes in with a power of attorney, hands it to the teller or hands it to the customer service representative, they can look at that and say, we want an outside opinion from an attorney that this document is still in full force and effect, has not been changed, revised, or amended. That's what you're telling me.
The law set up safeguards for that. So now we should have at least a reasonable belief that the banks will accept this. And other investment groups would accept as well. Well, okay, this draws to the conclusion of our program. And what do we expect the audience to take away from this? What should they get from this program? Becky, what are the highlights here?
Yeah, I think one of the main points is that a power of attorney document now under this new law has become something that you really need an attorney to assist you with. It's not something that you should pull off of the internet. It's not something you should try to do on your own. These new laws bring in a complexity to these documents, and you really should sit down with your attorney, make sure the document says what you want it to say, and make sure it's customized to fit your individual estate plan.
Jack?
Just very briefly, I think that our listeners, our viewers should expect that banks are going to be more cautious with every document that's presented to them, and I believe that the customer, who would be our clients, will have a better opportunity for their documents, power of attorney, to be accepted by a third-party bank and relied upon in the first instance without being upset and disappointed that perhaps their document may not be acceptable to a bank and may cause great delay in transacting whatever business that individual, known as the principal, would have transacted on at that given time.
Well, thank you, John Koury, Rebecca Hobbs. Thank you very much, and thank you for joining us. And hope to see you at least at our website and in our office as well. Thank you.